And that leads me to the second topic I'd like to talk about. That is the entrance of historians into the role of brief writers. That's how I got involved in the Goodrich case. The gay and lesbian advocates and defenders, the organization leading the case, asked Nancy and I to write a historian's brief supporting the Goodriches and the other couples in the case. GLAAD turned to us because we had written books and articles on the history of marriage, books that had been cited already in the briefs in the cases. But I think they turned to us for another reason as well. I think they turned to us because since the 1980s, historians have become more and more involved as experts in the appellate litigation process. Now, historians have been involved in law for a while. Historians have served as expert witnesses, most controversially in our world in the Sears sex discrimination case, but also in cases dealing with adoption, native land claims, a whole variety of other things. Historians have also been involved as consultants to lawyers and law firms, most famously the constitutional historian Alfred Kelly in the Brown case. And our work has always been expropriated in the Brandeis tradition by law clerks and judges. My dean sent me a congratulatory letter once about how pleased he was that Justice Scalia quoted my book. Quoted it for the wrong reasons in the wrong way, but, you know, the dean was thrilled. What happens in 1980 is something different. Then historians enter as experts, as friends of the court. It occurs, as I know many of you do know, in the 1989 Webster versus Reproductive Health Services case, a case that seemed to challenge Roe v. Wade. An NYU law professor organized a group of historians to write a brief arguing that reproductive freedom and choice was the policy legitimated by the past. Eventually, 400 historians signed that, including, I think, several almost dies. The Webster brief represented the first direct attempt by historians to inject their findings into a judicial decision and to legitimate that by claiming professional expertise and consensus. For the first time, historians, and not just history, was part of an appellate case. And it had at least two consequences. First, it legitimated a new practice. Since 1989, more and more historians have decided to use their expertise to influence judicial decisions by filing amicus cases in a wide variety of cases. Right now, there are 4 briefs being written by historians in a gun regulation case, just to give you one example. Secondly, and again as part of the discussion that I think we want to have tonight, it raised questions about historians as policy advocates, how we should use our expertise. But I would like to put that another way. Since 1989, historians have joined sociologists, psychologists, physicians, and countless other social and behavioral sciences and humanist scholars in grappling with these issues of how their expertise should be used. It's not just a controversy, a conversation, a debate. And that takes me to my final point, the Goodrich brief. Nancy and I were asked because history had entered this case before we did. In opposing same-sex marriage, the initial brief filed by the Attorney General of Massachusetts had 2 major historical arguments. First, the Attorney General argued that in fundamental ways, marriage in Massachusetts had been an unchanging institution. To allow same-sex marriage was a radical innovation not sanctioned by the past nor by the actions of any other state in the country. Secondly, and related, the Attorney General argued that radical change in marriage, if it were to occur, could only be made legitimately by the state legislature, not by the courts. And that spoke to a deep-seated history in this country of aversion to judicially influenced change, as we know and as we're experiencing today. And as I said, those initial briefs also cited in support of these propositions my work and Nancy's work and the work of other people. The other thing that the brief did is that it relied on affidavits filed in a Canadian case involving same-sex marriage. In that, historians had argued, one in particular, that marriage is a changing institution to a degree, but what he called postmodern marriage, contemporary marriage, was a needed but endangered institution and could not survive a radical change like same-sex spouses. So according to Glad, that Canadian case was the first time that historians became involved in marriage issues. So, we were asked, Nancy signed on first, I was then asked, I agreed for 3 reasons. First, I thought that the supporters of same-sex marriage had a better understanding of my work and the work of my colleagues than did their opponents, and I thought I needed to say that. Secondly, I believed that historical scholarship on marriage, women, race, the family, spoke directly to the issues in the Goodrich case, and that as a professional historian, I had an ethical obligation to use my expertise to explain why and how. And third, I read the stories of the 6 couples in the Goodrich case. One of the things that we all know is the power of stories. We try and use it in our writing. They used it on me. It was very successful.